Okay, order members. Honorable senators, the parties, ladies and gentlemen, welcome back to the open session. When we adjourned to go into camera session, the Senate retreated to make a determination on the application by the governor of Kiambu County to be allowed to file evidence out of time and for such evidence to be admitted by the Senate. The ruling on this matter is as follows. The application has not been allowed and is hereby denied. The effect of this is as follows, that the governor shall now proceed to put forth and argue his defense. 2, that the governor's defense shall be limited to the case filed by the county assembly and the evidence put forward by the assembly, including any matters which arose in examination and cross-examination of the witnesses. 3, the governor is also at liberty to canvass all the matters raised in his preliminary objection as was filed. 4, at the conclusion of the case for the defense, the parties shall each make their closing statements as appears on the hearing program, and the Senate shall retire to a closed session and afterwards to make a decision. 5, the program is adjusted accordingly, and the governor is invited to commence his defense and will have the original time of not more than 4 hours that was allocated. We will have a break at 1 p.m. for lunch. Honorable senators, parties, ladies and gentlemen, please note that in accordance with Rule 29 of the impeachment rules, this ruling is final. Counsel for the governor may now proceed.
Mr. Speaker, sir, members of the Senate,
Order,
constitutional principles, our constitutional standards, our precedents as the Senate. And I must say, I've been impressed by the Senate's insistence in all these reports on the adherence of the county assemblies on due process, threshold, nexus, and the standards that are now settled. In this matter, Governor Waitito, as a governor under Article 27 of the Constitution, deserves equal protection of the law. That is a right that is available to him, and we urge in the fullness of your consideration of this issue. You cannot be told that lack of numbers is a technicality. It is not a technicality. That question was settled by the Supreme Court in Raila Odinga petition of 2013, that where the Constitution prescribes a number threshold, then that number threshold is not a technicality. It is a substantive issue that must be demonstrated by evidence. And therefore, arguments will be raised that we have not presented evidence in regard to this issue. There was an admission before this House that it cannot be verified independently, even by a member of the County Assembly who moved the motion, that the numbers required to be realized were realized. Where there is such doubt, can you move? Can you move? Where there is such doubt, can you move then to remove the governor on the basis of that resolution? Where there is that ambiguity, then the benefit of doubt must be given to the governor. I rest by saying, on this question, my colleague will take up the other preliminary issue, that inasmuch as this matter relates to Kiambu County, it will settle the law on this unique issue, because that issue has never arisen in any of the impeachment questions that have come before this assembly. The question of numbers has never arisen. It is unique to these proceedings. And this is the opportunity for the Senate to insist on the county assembly that the requirements of removal under Section 33, the 1/3 approval, the 2/3 support must be strictly demonstrated before even such a resolution is admitted for hearing. Because it will be a sad day if we all gathered for 2-3 days to deliberate, discuss, and argue and determine a motion that is improperly before the House. That's why we raised this as a preliminary issue. It will be a manifest, unfair, and a very wasteful exercise if at the totality of the facts and the totality of the evidence demonstrated that indeed Senate was improperly moved. And therefore, honorable senators, it behoves this House, it is a responsibility that is given to you by the Constitution to investigate. To investigate. And I repeat, investigation for emphasis, that this is not a contestation between two parties alone. This is a contestation between two parties and an investigative organ properly constituted and the law. The Senate has capacity to even summon the clerk, summon the speaker, call for those logs, and demonstrate independently, even without our input, the integrity of the vote. The integrity of the vote. The issue of electoral and voter fraud is a live issue in this country. When it's raised, the Senate cannot prevaricate on it. It has to look at it, call for evidence, and what we have before you is an admission on two things. First, that detail, those particulars were not given to the House. Secondly, the mover of the motion and the witnesses of the County Assembly, even in the face of the preliminary objection, which they admit they were served with, and they knew that the issue of numbers was an issue in these proceedings, they did not lead any evidence. And the burden is theirs. Once a governor pleads not guilty, the burden is theirs to prove that the number threshold was realized. It cannot be a presumption. It cannot be assumed. It has to be demonstrated by evidence, empirical, admissible evidence, to a threshold as required by law. That demonstration, that evidence is absent. And in its absence, then the unavoidable conclusion, and this is my plea to the Senate, it must find that without that evidence, then there is no proper resolution upon which the Senate can move to determine whether or not the charges are substantiated. I rest on that point, and I wish to invite my colleague, Mr. Wanyama, to urge the second point of our appeal. Thank you so much.
Good morning, Senators, Mr. Speaker, sir. My name is Peter Wanyama. I will be making submissions regarding a very fundamental point, which touches on these proceedings, the constitutionality and legality of these proceedings. Mr. Speaker, sir, we have a problem. These proceedings we submit in terms of compliance with the Constitution, the provisions of the County Government Act, and your own standing orders are a nullity in law. Nullity in the sense that there are certain legal questions which then lead to the conclusion that if those legal questions are considered, then in your decision when you are retiring to make the final vote on the charges facing the governor, you must address that question first. And the question is on the question of timelines. It is, I know, difficult for you yourselves to make this decision because the illegality in question arises from a decision of the Senate itself in these impeachment proceedings, and not an illegality that arises from the County Assembly proceedings. So as I said, it's a very difficult decision to make. In court, it's very easy for us to make submissions for judges to recuse themselves when they don't have jurisdiction. So we are only repeating it here, but now the forum is different. Now, Article 189 of the Constitution 181 of the Constitution is express, clear, and unequivocal that the process of impeachment of a governor, in accordance with the grounds laid in Article 181 of the Constitution, shall be in accordance with the legislation enacted by Parliament. And the legislation in question is the County Government Act. The import of that is that the timelines which have been set in the County Government Act derive its validity from the Constitution itself. A response can be made that these timelines can be cured by the provisions of Article 159 of the Constitution, which provides that procedural technicalities are not supposed to impede access to justice. But our submission is that compliance with the provisions of the County Government Act is a constitutional imperative, is a constitutional command. The authority derives strictly from the Constitution, and therefore it can't be cured in any interpretation whatsoever. So in terms of that issue, it is important to emphasize that the Senate has no powers whatsoever to change provisions which have been put in statute. The only power that you have is to introduce an amendment to that section, which shall then go through the normal legislative process. And that is very, very, very critical. You are late by 28 days. The import of that is that you have no jurisdiction whatsoever then to consider the allegations which were leveled by the county assembly against the governor. An additional question: does the Senate have powers to extend these timelines? Do you have statutory discretion? Because normally if timelines have been cast in statute, and you read the statute in terms of interpretation, you will definitely find that some statutes can confer you with discretion to extend these timelines. So the logical question there is, do you have a constitutional or a statutory discretion to extend timelines by interpretation of the standing orders or by a ruling of the Speaker? My submission is that Section 33 has been cast in stone. Section 33 of the county government has been cast in stone, and it doesn't give the Senate in terms of discretion whatsoever. I submit that discretion in this case has been taken away. And in law, we usually say that discretion is like the hole in the donut. Discretion must be exercised within the confines of the parameters of law. If the law has given you discretion, then just like the donut, you must exercise within that confines. Otherwise, any decision that we make which is outside that hole in the donut is a decision which we submit is ex facie illegal. It is unconstitutional and cannot be sustained at all. And I want to also emphasize in terms of decisions which have been made by this House. Remember, Mr. Speaker, sir, this is a House of President. There have been more than seven impeachment proceedings which have been conducted in this House. At no point in time during the impeachment of Governor Wambora did the Senate extend these timelines beyond the provisions of Section 33 of the County Government Act. In fact, during the impeachment of Governor Wambora, the Senate had to sit up to 4 a.m. in the morning to comply with the strict timelines in statute. So that is very, very significant. During the impeachment of Governor Chepkwony, this House had to be called on recess, to hear an important matter concerning the removal of Governor Chepkwony. During the impeachment of Governor Mwangi wa Iria, timelines were strictly complied with. Timelines, Section 33 of the county government strictly complied. There was no deviation whatsoever, even by a minute. During the impeachment of the late Governor Gachagua, again, timelines were complied with. During the impeachment of Governor Samboja, again, timelines were complied with. During the impeachment of the Deputy Governor of Machakos, timelines were complied with. Now, it begs a fundamental question, a very serious question, which we can't run away from. Should Governor Waititu be subjected to a different impeachment test, a different impeachment threshold? What does it say about proceedings which are conducted in this House? What does it say about precedent, the rules regarding precedent which are binding to this House? What does it say about compliance with the Constitution on one fundamental question, which is the principle of equality before the law, which is a constitutional imperative, is a constitutional command, and let me just read it for the record and for the Hansard. Article 26 of the Constitution says, every person is equal before the law and has the right to equal protection and equal benefit of the law. Now, an impeachment proceedings which is being conducted in accordance with the provisions of Section 33 of the County Government Act, pursuant to the provisions of Article 181 of the Constitution, must be uniform. Every governor or deputy governor who comes before this House in an impeachment proceeding must be subjected to a similar standard of impeachment. Any deviation from that then calls into question then the legality of the process. So you can see that it is clear beyond peradventure that Governor Waititu cannot be subjected to an impeachment proceedings which is done at the discretion of the Senate and outside the provisions of Section 33 of the County Government Act. So we can run away from that issue, but it's a live legal question. The courts have ruled on the question regarding equality before the law. Every person must be subjected to a similar treatment and must derive benefit from the law. So why should Governor Waititu be subjected to a process of impeachment which is done 28 days after the statutory timelines? Isn't that a problem? So, Mr. Speaker, sir, I submit that we have a heavy and fundamental legal problem which can be cured by the provisions of Article 159 of the Constitution. Another comparison is very, very important. Another comparison. There are strict timelines in Article 144 of the Constitution regarding the impeachment of President and Deputy President. Those timelines must be followed. There's no way during the impeachment of a president or deputy president you can go ahead and change those timelines because they are cast in law. They are cast in stone. They can't be deviated from. Changing those timelines, then it becomes a problem. So in terms of the interpretation of the law, we must interpret the law in a manner that we create a multiple basis for consistency in in parliamentary decision making. So in this case, all we are asking for is consistency in parliamentary decision making. So there must be a multiple basis through which we exercise that power to interpret the law. So when you retire, that shall be the first and foremost issue. Sorry, first and foremost is in proper English. It shall be the first issue for this House to consider. It shall rank first in time. The moment you discover that Mr. Speaker made a mistake by convening this House 28 days after the statutory timelines, that is the moment that then you vote and say, we can't allow an illegality. Because the moment you allow that illegality, you are setting a dangerous precedent in the application of that particular section in this country's legal history. The other comparison, election petitions in law are strictly conducted within the timelines which have been set. It's just a comparison. There's no way you can extend the timelines which have been put by statute in terms of election petitions determination. Those timelines have been set, again, pursuant to a constitutional process and implemented by statute. And there are policy reasons why those timelines have been cast in that manner. There are policy reasons why it is important and critical that impeachment proceedings against a governor be determined within the statutory timelines provided for in Section 33 of the County Government Act. Remember that a governor is elected by the people, and therefore, Article 38(3) of the Constitution, the governor has a right to hold office. The governor has a right to hold that office once elected. It's a right in the Bill of Rights. And therefore, to take away that right, there can be no substantive impropriety in the process of taking away the governor's right to hold the office through an impeachment proceedings. And this taking away, this technicality we submit is substantive. It is not merely a procedural question, which, as I submitted earlier, can be cured by the provisions of Article 159 of the Constitution, or a ruling of the Speaker varying the standing order. So we submit that the Honorable Speaker made a substantive and a fundamental mistake, a serious mistake, which casts doubt to the legality of these proceedings, and it can only be cured by a rejection of these proceedings. So let me just highlight what the courts have said regarding timelines. I know our documentations were rejected. So I'll just read into the answer what the Supreme Court said concerning timelines. In the Raila Odinga, under Section 60 of the Evidence Act, courts of law are usually required to take judicial notice of the existence of decisions, of judgments and all that. So we submit that a similar comparison can be taken in this House, because it's a quasi-judicial process, that the House can take parliamentary notice of the existence of Raila Odinga versus Independent Electoral and Boundaries Commission and others, 2013 EKLR, where the Supreme Court, the highest court in this country in terms of the doctrine of judicial president, and therefore its decisions are binding, says, in respect to compliance with timelines, as a matter at paragraph 29, as a matter of fact, if the timelines amount to a procedural technicality, then it is a constitutionally mandated technicality. So we can borrow the same submissions here. If compliance with Section 33, which derives its authority from Article 181, Paragraph 2 of the Constitution, creates a technicality in terms of procedure, then you are bound by it. You cannot change it. As I said, there's only one way in which you can change it when you are sitting as Parliament, through an amendment of legislation to provide for other timelines. So, Mr. Speaker, sir, we are really emphasizing that issue because it's at the core of this impeachment proceedings. So, Mr. Speaker, sir, we are submitting in summary that there's a serious and egregious breach of Section 33 of the County Government Act, occasioned by an official act of the Speaker in convening the House after 28 days after the statutory timelines which have been set. And just like a court of law, you then have powers to correct that mistake by ruling that indeed you have no jurisdiction to look at this issue, to look at the impeachment allegations against the governor, and proceed to make a decision accordingly. And the decision, Mr. Speaker, sir, that we are seeking is a decision to reject the impeachment against the governor and determine that the charges have not been substantiated. Mr. Speaker, sir, on the second issue, there's an additional issue there, Mr. Speaker, sir, which we can emphasize now in terms of summary. Mr. Speaker, sir, the impeachment is a quasi-judicial process. And Mr. Speaker, sir, in view of that, there's a legal question which arises again in these proceedings. The legal question is, can the governor be subjected to impeachment proceedings based on matters which are sub judice? Mr. Speaker, sir, from the proceedings of the County Assembly, a legal question now has arisen. If you listen carefully to the submissions which were made by the County Assembly, it is clear that there are certain matters which are being canvassed in a court of law. And therefore, Mr. Speaker, sir, Standing Order number 98, your own rules of this, the rules of this House, prohibit discussion on matters which are sub judice. And the legal implication is that if you proceed to make a determination on that matter, you will be breaching that principle of sub judice, which is covered in your own standing orders. So we submit that you need to show some deference. Any matter which is you are being called upon to make a decision on, if you find that they are in the proceedings which are in a court of law, we submit that you need to apply your rational mind, apply that rational basis test when you are deciding, not to look at that matter, because it will open up a Pandora box then of saying that you have breached the standing orders. Courts are prohibited also from looking at matters which are pending in Parliament. So in similar vein, then Parliament is prohibited from looking at matters which are pending in court. Mr. Speaker, sir, the political question doctrine, any matter which covers the ambit of a political process, the so-called political questions, are matters which this House can conveniently handle. An impeachment proceeding being a quasi-judicial proceedings, then proceeds on the basis that those questions can then be addressed so long as they are not pending in court. And if they are pending in court, it will heavily prejudice. It is like subjecting the governor to two processes. One, an impeachment proceedings, which is really quasi-judicial proceeding, and then the other one is a court process, which then undermines the rule of law. As I submit, there are also policy reasons why rule number 98 exists in the standing orders. Again, rule number 98 is meant to, again, lay basis for consistency in decision making, so that there is harmonious workings of the different arms of government. And therefore, the governor has a legitimate expectation that those matters which are in court then should not be considered here, because they will heavily prejudice the governor. And when you're examining this question, I invite the House to look at the evidence which has been tendered by the County Assembly and the charge which the governor faces. Because that then will clear the issue in that perspective for determination by this court, so that we don't expose the governor to what is called a double jeopardy, subjecting him to two processes, and therefore it becomes extremely and highly prejudicial to the governor. So thank you very much. I'll be coming back later on to make submissions on the threshold on the County Assembly's case. Thank you. That is all for the PO, Mr. Speaker, sir.
We are still arguing our POs. There are 4 points on the PO. I will be very, very brief on the 2 that are remaining. I do not want to tire honorable senators with legal arguments, but they're important. We are defending a man whose job is on the line. So kindly allow us to quickly go through the motions of our 2 other remaining arguments. First, in our PO, we have isolated the issue of compliance with the standing orders of the Kiambu County Assembly. And I'll do no more in that regard than refer honorable senators to standing order number 82 of the County Assembly of Kiambu that provides at part 2B that a special motion in the nature of a removal of governor by way of impeachment should be disposed of within 14 days. That is the prescription of the standing order. What is the factual reality of these proceedings? It is conceded by the move of the motion that the motion was introduced on the 3rd of December, 2019. It is also conceded, and the communication is clear from the Speaker, that that motion was argued and disposed of on the 19th of December. That was well outside the standing orders of the Kiambu County Assembly, which provide for a 14-period limitation. If it's not disposed of within 14 days, then that motion is no longer tenable, it's no longer sustainable, it's no longer arguable as a motion under Standing Order 82, and capable of activating the proceedings for the removal of the Senate. Senate is mentioned under Section 33 with the limited function within the prescribed time. It is very difficult to make a decision that appears to undermine your jurisdiction. That we concede. But this is an institution established and governed by the law. So your first allegiance should be to the law. And that is our simple request, and that is our prayer, and that is our submission. The last issue that we raise as a preliminary objection is the question of public participation. And these issues are set out in our PO. And I will not urge any facts in support of that PO other than the deficiency or the complete lack of evidence by the County Assembly showing that there was any public participation. I remind the House that this is a settled issue by this House. The Senate said in the special committee considering the issue of Professor Chepkwony, Governor of Kericho, that public participation is a necessary constitutional prerequisite, and that has to be demonstrated by the County Assembly. That is a finding of the Senate. Senate is bound by its own finding. On the material that was presented before this House by the County Assembly, there was no evidence whatsoever of public participation. Court of Appeal in Civil Appeal number 192 of 2015, the case of Martin Nyaga Wambora, also spoke to that issue. And the court said, and I do not wish to read the entire judgment, but the court said that impeachment of a governor is such an important issue of a constitutional moment that the public ought to be facilitated by the County Assembly to participate in. And on that ground, the decision of the Senate and the County Assembly of Embu in that instance was set aside by the Court of Appeal. So it is an issue that this House is enjoined to consider, and our submission is that absent any demonstration of public participation, then the resolution before this House is constitutionally deficient and incapable of supporting the removal of the Governor of Kiambu County as proposed, and therefore must fail. We therefore pray and ask the Senate, honorable senators, to consider our interventions on points of law by way of this notice of preliminary objection, and in full evaluation thereof, you will find that they all have merit based on the evidence that is already on record and based on evidence that is of a public character and for which Senate has power to take judicial notice thereof under the Evidence Act. I shall now call my colleague to respond to the substantive issues raised in the charges.
Honorable Speaker, honorable senators, you've been taken through the legal deficiencies of the motion that was presented to this House by the Assembly. Mr. Speaker, following the directions and the ruling you gave, I will now speak to the factual and evidentiary deficiency of this impeachment as presented by the Assembly. Mr. Speaker, I will start my discussion on a rendition of what the standard that should be met by the Assembly is. an oft-cited decision, and I'm happy that the Assembly in their opening remarks cited it, is the decision in Martin Nyaga, Wambora, and others versus the Speaker of the Senate, which is reported 2014 EKLR. And I want to start my discussion, Mr. Speaker, by quoting a finding of the Court of Appeal on what impeachable conduct constitutes. Mr. Speaker, the Court of Appeal had occasion to consider that matter, and in its wisdom gave the following rendition of the law: that to our minds, therefore, whether a conduct is gross or not will depend on the facts of each case, having regard to the article of the Constitution or the law alleged to have been violated. We find, however, that it is not every violation of the Constitution or written law can lead to the removal of a governor. It has to be a gross violation. So that, Mr. Speaker, the Senate may very well find certain violations, but not every violation of the law constitutes an impeachable offense. Mr. Speaker, in the same decision, the Court of Appeal went on to say that that violation must be serious, substantial, and weighty. So that this Senate, in its consideration of this impeachment motion, will need to ask itself, has that standard of being serious, substantial, and weighty been discharged by the Assembly? So that it is not just pointing out that there was a legal infraction. What is the nature of that infraction? Mr. Speaker, I'll revisit that shortly as I delve deeper into the various allegations, Mr. Speaker. Mr. Speaker, in a case from the Supreme Court of Nigeria, again, which we had occasion to cite in previous impeachment, Honorable Muia Inakoju and Abraham Adeolu Adeke. The Supreme Court of Nigeria had occasion to consider again the issue of what an impeachable offense is, and had occasion to say as follows: that a governor as a human being cannot always be right, just like no human being can always be right. That explains why Section 188, I'm quoting that decision, talks about gross violations. Again, repeatedly, gross violations. Where a misconduct is not gross, then the weapon of removal is not available to the House of Assembly. That is the Supreme Court of Nigeria. So that, again, the question that you need to continually grapple with after having listened to the evidence that was tabled yesterday are those infractions. First of all, we will be showing you that they were not proved. But even if you are to find that they were, do they rise to the required standard? I'll revisit that in a short while. Mr. Speaker, there are various decisions. Again, I don't intend to take you through. There was Mwangi Wairia decision, which again I had the opportunity to participate in. And again, where violations were found, infractions were found, some of which mirrors what is before this Senate, including, Mr. Speaker, allegations touching on pending bills. But they were all rejected, not because they were not proved, but because in the wisdom of the Senate, they did not rise to the required standards that would constitute this, that would constitute invoking the ground for removal. Mr. Speaker, in the same decision, Martin Wambora, this is a standard that the Court of Appeal set, that given that this is a sui generis, quasi-judicial, investigative process, the standard is certainly beyond a balance of probability, but slightly below
Order.
a
Senator-
reasonable doubt.
Senator Mogeni, what is your intervention?
Thank you, Mr. Speaker. Mr. Speaker, I want to seek the guidance of the chair. According to the program, we should be receiving evidence by the governor, either evidence of witnesses, if any, or cross-examination or re-examination in chief, according to the program. Then, thereafter, we are supposed to receive closing statements, and there's a sequence of events. First, we need to listen to the county assembly, and thereafter, we get closing statements on behalf of the governor. But having listened to counsel for the governor, I'm getting the impression that we have mixed up the program. It's like what we are now getting are closing statements from the governor, where counsel is summing up the legal issues and making an address to the Senate. Can I have guidance from the chair whether we have altered the program, whether we are at the stage where we are getting closing statements, or we are at the stage where we are supposed to be receiving the evidence of the governor? Thank you, Mr. Speaker.
Senator Kabaka.
Mr. Speaker, sir, thank you. I don't agree with Senator Omogeni, senior counsel, with regard to what he's trying to tell this Honorable Senate, because already, Mr. Speaker, sir, you have ruled that there is no extension of time to submitting evidence. What other evidence does he require the side of the governor of Kiambu legal team to present, other than arguing the 4 critical points on the appeal? Thank you.
What's your point of order, Senator Murkomen?
The Speaker, you ruled earlier. You ruled yesterday first that the lawyers of the governor will make their application for PO together with their substantive response to the charges, which denied them the opportunity to make the PO before the county assembly makes its case. That prejudiced the governor from succeeding in this house later to bring evidence, because this house says, as a result of the ruling of yesterday, there cannot be other evidence because county assembly has closed its case. Now, there is no evidence that is admitted as per your ruling, meaning the only thing that the governor's advocates can do is to haze around responses to the charges using points of law and facts that are available to us without really going to any evidence, because there is no evidence as ruled by this house. And being a person who was supporting an admission of this evidence, you can see where we are going.
Senator James Orengo.
Mr. Speaker, if you look at the rules, there is some justification from what has been said by senior counsels, Senator Omugeni, and also what has been said by the leader of majority. The only confusion that is arising is that the counsels for the governor have termed what they are doing now as a preliminary objection. What I understood them to be doing is making a response to the case that has been laid out by the county assembly. And I think if they are presenting or reacting to the case that has been presented with the county assembly, then the governor should not be shut out. But there's going to be another opportunity when the closing statements are going to be made. And Mr. Speaker, you would see from the standing orders that each side has got only 30 minutes for closing. which means they've got to be very brief. Is it? I think it's 60. Yeah, 60 minutes. That's a very short time, actually. So I think they are doing the right thing, but calling it the wrong name. Because if it's a preliminary objection, for example, when they are saying we have no jurisdiction, they should not be had to be saying anything else other than talking on the question of jurisdiction. Because why you do want us to consider the evidence when we don't have jurisdiction? So I think is a misnomer for them to call it a preliminary objection. They should say they are making statements, including the statements they're making about jurisdiction, in answer to the case that has been made out by the county assembly.
Senator Mtula Kilonzo Jr.
Speaker, I'm of a different view that my learned friend Peter Wanyama has argued forcefully that we should don our tools and go home, and they're arguing many things. I think that since they have chosen the mambo jumbo and the recipe of what they want to do, we give them their time, argue as they please, present what they want, and then close. Because they have really chosen how the modus operandi of their case. They have chosen what to do. I think if we intervene, then we'll be looking as if we want to advise them, and the governor has paid his legal counsel fees to advise him. So we are not supposed to advise them. Let them conduct their case. These are very, very senior lawyers of the profession, carrying a lot of respect from all of us. So I think they have their time. Tell them how much time they have. Them continue. We are going to sit here patiently, only that in the case of Wanyama, we never sat until 4 a.m. We can't sit until 4 a.m. So we will not sit until 4 a.m. Thank you, Speaker.
Senator Wetangula.
No, Speaker, the governor and his lawyers find themselves in a very difficult situation, because ordinarily those of us who go to court, the sequencing of cases is not what they find themselves in. We've put them in a box where they are now supposed to navigate between a preliminary objection post-hearing and the hearing itself, as per your own ruling. So whatever the jumbled situation we may find ourselves in, I think this House has the capacity to sift the wheat from the chaff at the end of the day and determine fairly what should be done. So let them argue their case in the manner they best know, within the circumstances they find themselves in. At some point, I believe they'll call their client to testify, depending on what they want to do. And I'm sure this House and these distinguished senators are able to know how to skin the cat, whether start with the tail or the ears or the head or the back, whichever. Thank you, Mr. Speaker.
Okay, thank you for your inputs. I directed you proceed in the manner you are proceeding. If by the end of it, the statements will end up saying the same, so be it, but proceed. Senator Sakaja, what's your intervention?
Mr. Speaker, again on behalf of the unlearned friends, but highly educated, the direction sought by Senator Mogeni is key, because of course, as Senator Rengo said, it's a misnomer. It's not a preliminary objection. One, it is not preliminary, and number two, we're already in the meat of the substance of these charges. Mr. Speaker, what direction we need is just for you to tell us how much more time that they have left, because we can't just go on into perpetuity, Mr. Speaker. Please direct as such.
Oh, I'll do that, but I can see Senator Ongeri.
Yes, can you hear me now? Thank you very much, Mr. Speaker. I think yesterday you gave a ruling and that ruling, and you gave us a litany of rules of procedure that we are supposed to consider. Senior Counsel Okongo Mogeni has raised a preliminary guidance from the chair whether in the manner which we should proceed is right or wrong. I refer you to the Rules of Procedure 2, subsection B, where it says, determine whether the particulars of the allegations against the governor have been substantiated. I expect the counsel for the governor to be able to strictly be able to give us that evidence, because that's what we are looking for. And at the end of it, we'll be able to decide which way the evidence weighs. I will plead with you, Mr. Speaker, that in order for us to order our thinking chronologically, that we go according to the program which has been laid out.
Order, senators. I have made a ruling on this matter. Let the council proceed.
Thank you, Mr. Speaker, for that guidance. Before I delve into the deficiencies of the Assembly's case, I was just setting out the standard. It was really a background, because from the guidance that we received from Mr. Speaker, is that even in the absence of our evidence, it is open to us during our defense to comment on the evidence and the case as presented by the Assembly. So I'm starting with the standard, the threshold, then I can delve into the actual charges and the alleged violations. Mr. Speaker, I was on the standard that was set by the Court of Appeal, again in that famous case of Wambora, and the standard is again slightly below, actually it is on it's between a balance of probability and beyond a reasonable doubt. So that the appreciation of the Court of Appeal is that the allegations and the charges which are premised under Article 181 must rise to that very high standard. Mr. Speaker, the burden to discharge that proof never shifts. It is always, Mr. Speaker, the Assembly's burden to discharge. So that in the even in the absence of evidence by the governor, if the evidence by the Assembly does not meet that standard, then their motion must be rejected. Allow me to point out, Mr. Speaker, again, just for the comfort of honorable senators, that in as much as we argued the preliminary points of law and now we are delving into the merits or otherwise of the Assembly's case, it is following your guidance that when you retire to consider the matter in plenary, if you find you have no jurisdiction, then as Honorable Senator Mutula Kilonzo has pointed out, you will down your tools. There are many times courts will guide us and say, argue the preliminary objection and the merits of an application together. So it will still be open to the Senate to down its tools. But should it still find that it has the tools to intervene, that's why we are now considering the merits. And allow me, Mr. Speaker, to now go straight to the evidence that was presented before the Senate by the Assembly. Mr. Speaker, this Senate was told that there has been violations of the Public Procurement and Disposal Act and the Constitution, which were said to be gross. And the particulars, Mr. Speaker, were that they are pending unsustainable bills within Kiambu County. Mr. Speaker, I wish to pose this question, honorable senators, that how can pending bills, some of which have been inherited from previous regimes, constitute a gross violation of the law as to become an impeachable ground? In a humble submission, it is not. Mr. Speaker, if we were to sustain the fact that there has been pending bills in Kiambu, then perhaps then this Senate will be required any time a motion is presented from any of the 47 counties, because all of them have pending bills. And this is a matter of public notoriety, that it has to uphold such a motion. The other question that perhaps needs to engage this Senate as you consider that allegation is really the role of the governor. What's the direct role of the governor in as far as incurring of these so-called unsustainable debts are? Was there any evidence that were tabled linking the governor directly in terms of the nexus that was set out in Wambora's case? None at all. None at all, Mr. Speaker. And in our very humble submission, that allegation has not been proved. Mr. Speaker, some of the reasons that constitutes, again, pending bills, and this is a matter the Senate has had to grapple with when, for instance, in their oversight capacity, they've summoned governors and CECs of various counties, is what may have caused this. And one of the things, Mr. Speaker, this Senate may have noticed is that there has been cases of delayed exchequer releases, delayed completion of projects that extend across several financial years, emerging issues that arise from budgets, fluctuating local revenue sources, pressure from projects, etc., etc. So that there are a host of external factors, Mr. Speaker, that brings about a situation of pending bills, but which has nothing to do with the culpability of a governor. Mr. Speaker, you were told by witness number one that there is a gross violation in relation to tendering and contracts. Mr. Speaker, the evidence that was adduced was that there is at least a schedule of so-called contracts amounting to over 3 billion shillings. What you noticed during cross-examination is that not a single contract was produced. Not a single award of tender was produced in the hand of the governor, Mr. Speaker. But now you're being told that because there's a list showing contracts of 3.3 billion shillings, find the governor to have violated the procurement law and therefore amenable to impeachment. Mr. Speaker, that cannot be a serious basis, with all due respect, Mr. Speaker. You were not told, Mr. Speaker, the role the governor directly played in issuance of those alleged tenders. First, we never saw them. But I think much more significant is what role did he play? Was that evidence-led? None at all. There's a dearth of evidence in as far as that question is concerned. But now you're being told, merely because a sensationalized figure of 3 billion shillings has been mooted, you need to impeach the governor. That cannot be a serious ground, Mr. Speaker. You need to be told in the entire procurement process, where does the governor come in? Does he evaluate tenders? In this case, did the governor under trial or on trial evaluate any tender? Did he award any tender? In what manner did he directly contravene the procurement law? That you are not told, Mr. Speaker. But then you are being told, impeach him on that ground. You are told that tenders were granted for roads because he was to receive a tithe. 10%. Of course, it is very, it's very flowery to say 10%, like we tithe in churches. But were you shown evidence of any money that came from any contractor so that the governor can be said to have derived a personal benefit from these so-called tenders so that you can sustain that ground? None at all. Whose burden is it to discharge that? It is the assembly. The burden never shifts. It is not for the governor to bring evidence and say, I did not issue tenders, or I did not receive kickbacks. They are saying he received. Where is the evidence? None at all, Mr. Speaker. Mr. Speaker, how can infractions of failure to disclose pending bills in the fiscal strategy paper amount to an impeachable offense? How, Mr. Speaker? Yes, it may be an infraction. Are there other oversight mechanisms that the Assembly may have deployed to redress that? Certainly, yes, Mr. Speaker. Were they deployed? None. Failure to set up County Budget Economic Forum. Mr. Speaker, first, it was not shown. Part of the evidence that we received late was a schedule, Mr. Speaker, showing members of the County Budget Economic Forum. But again, which and we respect the decision of this Senate, we were not able to tender because the Senate was of the view that but there is a budget forum. Our submission is that they needed to show. It is not just allege and push the burden to us. Show that it does not exist. And even if it doesn't exist, Mr. Speaker, I am aware that during the consideration of the impeachment of Governor Mwangi wa Iria, Governor of Murang'a, that issue came up. It was cited as an infraction. Did it amount to an impeachable ground? Certainly not. And in the wisdom of this Senate, they went ahead to say that yes, there may have been violations. Yes, there may have been infractions. But we believe that other oversight mechanisms and methods would have been deployed to redress that. Mr. Speaker, it was alleged that the governor has committed a crime against national law because a report from the ombudsman, beg your pardon, implicates the governor. Mr. Speaker, it's like taking a newspaper report that alleges that somebody committed a crime and now presenting it before this Senate and saying that a crime has been committed. What I am happy about, Mr. Speaker, is that this Senate is comprised of noble men and women who are intelligent enough, Mr. Speaker, to appreciate that a report cannot constitute a crime. The lady who is said to have been defrauded of the land is a lady who would have come, taken oath before this Senate, said, I dealt with Governor Waititu. He did A, B, C, D, and I lost my property. Mr. Speaker, that was not done. You are not even told that the DCI has commenced any investigations. What you saw was an affidavit. So why would Cecilia be happy to sign an affidavit and not present herself for cross-examination before this Senate, so that this Senate can be satisfied that Governor Waititu was beneficiary of a fraud committed against her? What was being hidden? That's a question I would urge this Senate to bear in mind in consideration of this matter. There is a question of conflict of interest. Mr. Speaker, conflict of interest has to do with what benefit accrued to the governor personally, because that's the key element of that crime. What you were told is that there are CR12s of persons who could not be demonstrated to be the governor's kin, merely because Cecilia, somebody Ndongo, bears the name Ndongo. I am sure there's so many Kenyans in this country, if you go to the registry of persons, who bears the name Cecilia Modoni Ndongo. I'm George Ngangambugwa. A CR12 that shows I am a director and a shareholder does not necessarily mean that I am that George Ngangambugwa. A higher standard is required so that it behoves the assembly to go ahead and say why we are saying this person is this and related in this manner is because of 1, 2, 3. And even then, that is not where the Senate stops. Was there personal benefit that accrued? That you were not told, Mr. Speaker. So that it is very easy to sensationalize and say we have a CR12. But that is not enough, Mr. Speaker, to constitute an impeachable ground and a conflict of interest. It is also worth noting, Mr. Speaker, and this is again a matter that this Senate can take judicial notice of, that we have charges which are pending in an anti-corruption court. The governor has presumption of innocence under Article 50 of the Constitution. He pleaded not guilty to allegations of conflict of interest. The matter has not even commenced. Not a single witness has even testified. But now you're being told, Mr. Speaker, pronounce yourself on this question involving alleged conflict of interest based on the material that has been provided to you. Mr. Speaker, the standing orders of this Senate gives deference to a court of law that is seized of a matter such as the one that is presented before you. Mr. Speaker, how can alleged failure to release funds to the Assembly? First and foremost, did the Assembly produce a statement of accounts saying that for this financial year, we were entitled to release of this amount of money? The amount of money that was actually sent to us from the executive is this much. This was not sent. Now we are being told, Mr. Speaker, you need to disprove that. First of all, the governor has no authority to incur expenditure. The head of the county treasury should be perhaps the one on trial. that who is the accounting officer? Has the governor been shown to be the accounting officer? Because he does not incur expenditure. He does not authorize any payment. But even then, Mr. Speaker, has the county assembly said that this is what we were entitled under the budget, this is what was authorized by the COB, this is what actually came into the county treasury, and this is what you released to us. This you did not release. What reasons do you have? Has that been placed before this Senate? Mr. Speaker, that was not done. Yesterday you heard from witness number 2. Witness number 2, who is a legal advisor of the Deputy Governor Nyoro, who was employed by the Deputy Governor himself, took the initiative, allegedly as a public-spirited citizen of Kiambu, wrote to the Ombudsman, not on any other question, the question of alleged fraud touching on the governor. If he was that public-spirited, how come he never wrote to the Ombudsman asking about any other investigation? And why him as the legal advisor to the deputy governor? Mr. Speaker, what was the motive? Because the bona fides must also be investigated, so that we do not allow as senators tough wars or issues which are parochial in nature to cloud the thinking of this Senate. It is a respectable, august house. This gentleman came and said, this was my role. So you can tell who is wagging the tail. But that is the evidence that now this Senate is being called upon to uphold and impeach the governor. On the question of appointment letters, a witness chickened out. Apparently the witness who you are told could not testify because witness number 1 touched on issue of appointment is a member of the Public Service Board. Ask yourself a question. How come a member of the Public Service Board that does recruitment, that does shortlisting, could not come and say, senators, on this question of these casuals, we did not recruit? The governor may have issued letters. There is nothing barring him as the chief executive to issue a letter of appointment subsequent to a recruitment process. You are told that the letter must refer to minutes of the board. Were you shown a proviso within the law that says that a letter of appointment must state when you are shortlisted, when the board sat, etc., etc.? Were you shown that? But now you're being told, Mr. Speaker, there were 600 casuals. EACC intervened. Did we even get a letter from the EACC challenging the recruitment? But it was said on oath. So it was very easy, Mr. Speaker, for that witness, whom you all had a chance to listen to, who prevaricated all through and was very evasive. And that was their star witness, Mr. Speaker, whose objective was to come and nail the governor. He was the mover of the motion. He had all this material. But that is the evidence, Mr. Speaker, that you're not now being told has risen to the threshold set out in Wambora's decision. Slightly below the standard that is required, Mr. Speaker. That is the evidence. It is beyond a reasonable doubt, but the standard is just slightly below. Now, that is the standard you're being told to uphold, Mr. Speaker. Mr. Speaker, it is not about the governor. It is not about Honorable Ferdinand Waititu. We all aspire to hold these offices, Mr. Speaker. What I am happy about is that this Senate is not there to validate. In fact, by you clearing the governor, it's not that you're saying that there has not been infractions. There may be, just like other counties, Mr. Speaker. But all we are saying is that, and that's why we set out all these issues about due process and threshold. Let us be consistent, just like this Senate has consistently been consistent about the standards, so that we do not then make it very easy, Mr. Speaker, for assemblies to simply just converge, come up, craft a motion, pass it through a very opaque manner, without even disclosing the numbers, and bang, Senate, we invoke your process. That is trivializing a very noble house. It is trivializing, Mr. Speaker, the impeachment role of this Senate. You will be sending a message, not that this Senate was favorable to Honorable Waitito today. No. It is that before we are seized of this matter, these guarantees are bare minimum, and they must be met, Mr. Speaker. So that what we are saying is that the threshold has not been met. Let the Senate, in its report, Mr. Speaker, and that is what we shall be urging, that even where it finds that there may have been omissions, say that these are oversight mechanisms that can be deployed within Kiambu and that can redress these issues that have been raised by the Assembly. And be very hesitant, Mr. Speaker, to invoke the weapon of impeachment and remove the Honorable Governor, Mr. Speaker. That's as far as the threshold and the merits of their case is concerned. And so, Mr. Speaker, I want to yield now. I don't know how much time but perhaps maybe, Mr. Speaker, what I just want to, for the comfort of the senators, is that when we are making our closing arguments, we'll actually be extremely brief, because part of what we have covered in our defense was very substantial, and it also touched on our closing argument. So we'll not wear the senators again down with a rehash of the same arguments, Mr. Speaker. Thank you very much for your time. We really appreciate it.
Okay. You have 2.5 hours to go.
I can assure the Honorable House, Honorable Senators, we do not intend to be here for another 2.5 hours. We shall endeavor to finalize, and as soon as we have nothing useful to add, we shall rest. But it is our duty to insist on one thing, that the standard that has been applied repeatedly in such proceedings be adopted and used in the present proceedings. And we will not tire to repeat that, because Governor Waitito is entitled to equal protection, equal treatment before this Honorable House. Standing Order number 2 of this House enjoins the Speaker and indeed the House to adopt precedents of the House. That is a provision, a positive provision within the Senate's own standing orders. I say that to lay basis of a comparison of how this Honorable House has processed previous similar charges. These charges are not unique to this House. These charges have been heard, of course, with slight modification, slight variation of facts, slight variation of numbers, but they have been heard by this House. The first issue and the first ground, without reading, relates generally to pending bills and debts within the county. The question is, how has Senate treated that matter before? In the special committee that was investigating the proposed removal of Governor Mwangi Wairia, and I have a copy, it's available, I'm sure, from the clerk's records. The allegation against him was that the county executive has contributed debts and accumulated debts to the tune of 2.8 billion on the county. In Kiambu, we have been told 4 billion. What did the Senate say? The Senate said that it is not possible to ascribe liability to the governor on the issue of debt without interrogating the position of the controller of budget on whether those funds were available, the position of the Auditor General with regard to the question of whether this debt constitutes LPOs or orders or invoices and such other material considerations. And the Senate said that although there appears to have been certain things that were not done, this is not an impeachment question. If it was not an impeachment question for the governor of Murang'a, it cannot be in the proper reading of the standing orders of this House, and the precedent set an impeachment question for Governor Waititu. That is fairness, that is justice. There was the same issue of failure to establish a county budget forum to publish a county fiscal strategy paper. That was also a ground in the same special committee and the allegations before the Senate. In fact, that was ground allegation number 5 in the record on the allegations against the governor of Murang'a at that point. And the county said, and the Senate said, and I'm reading the ruling of the Senate in that matter, that although there appears to be a violation of the County Governments Act, the violation did not rise to the level of gross violation and was therefore not substantiated. The committee and the Senate recommends that the governor sets up the county budgets and economic forum as required under section 137 of the PFM within 90 days. The resolution of the Senate was a recommendation to follow the law in that regard. It was not to remove the governor. And so we ask, in the face of the same allegation, of course with slight variations, in fact, I think they used the same template, can it then become and mutate and be treated differently as an impeachment question for Governor Waititu? That would be manifestly unfair. It will be treating two governors facing the same charge unequally and differently. National laws. It has also come to this House as a ground, as a charge. It was a charge against Governor Wambora and also Governor Wairia. It was ground charge number 2 in the charge sheet against Governor Wairia. And the Senate said, in this report which I have, that in the matter of alleging commission of a crime, then the evidence that should be brought to the House as evidence supporting such a ground is a conviction, because an allegation can be made on any set of facts. And on that ground, the committee and the Senate found that that was not an impeachment ground. I submit, and I say, and I commend the reading of this report by the honorable senators, because it was prepared by this House. The House cannot run away from it, that you follow the same reasoning, the same analysis of facts, the same analysis of the law, and when you do that, you will arrive at the same conclusion, that the ground of commission of crime, unless backed by a conviction, is not a sustainable impeachment ground. That is the standard of the Senate. It is documented in the report. Abuse of office, charge number 3 against Governor Iria. The Senate said, and I read verbatim, the committee unanimously found that there were violations of the law. The violation did not rise to the level of gross violation and was therefore not substantiated. The committee recommended, this was a matter of spends by the governor on county billboards, on county advertisements and all that. The Senate found that that was not an impeachment question. And on that ground, in fact, the committee said, in future, any governor who contravenes these provisions of the law should be surcharged for the cost of advertisement. The reasoning of the Senate was, where there is available alternative remedy, then the tool of impeachment should not be deployed as a matter of course, because then it demonstrates that it's not being used in good faith. The last illustration before I sit is in the issue of employment matters. They've also come as an issue of impeachment as grounds against governors. And the Senate has had occasion to interrogate the same charges. In this case, the allegation was failure to appoint a chairperson of the board and interfering with the processes of the board. That is the County Public Service Board. Senate said that on employment matters, the County Governments Act provides sufficient remedies, and unless the County Public Service Board complains that there is personal interference by the governor, then it's not an impeachment issue. In this case, the complaint is not by the County Public Service Board. In fact, the witness who had filed a witness statement said, to his mind, there is no wrongdoing on the part of those who are hired allegedly by the governor. Of the committee of Senate in the matter of the proposed removal of Professor Chepkoni, an interesting finding in conclusion was made by the Senate at paragraph 243. And the comment was that the committee finds that the governor has not abdicated his role as governor. He has, however, breached the law in some instances as a result of combination of certain factors. These challenges, if recognized and acknowledged, can be remedied. That was the Senate speaking. These challenges, if recognized and acknowledged, can be remedied. The committee did not find that in the Kericho governor, an individual was hell-bent in violating the law or abdicating responsibility. And therefore, the totality of the decision was that it is not appropriate in these circumstances to remove the governor. This is the standard set by the Senate. Has Governor Waitito, on the evidence available, abdicated his role as governor? Has he been shown as a person hell-bent on violating the law intentionally? Has he been shown to consistently defy or disregard recommendations? If not, and I submit that none of those factors have been demonstrated, if not, then the appropriate recommendation is that he should not be removed, but those matters can be resolved by utilization of certain institutions, certain laws, and enforcement thereof in a strict manner. We therefore commend and urge that the same stick, Senate holds a big stake against governors under Article 181. But the same measure, the same stick used against the other governors should be applied against Governor Waititu. You cannot change the stick and the intensity and the measure thereof, or the number of canes, because now we have Governor Waititu. Fairness demands that equal wrong be treated equally in terms of remedy. We make no admission on wrong, but should peradventure such be found, then the resolution thereof has already been prescribed, detailed, given with material and very lucid reasoning by the Senate Committee and the Senate. That is our plea, and that is our application, that on the evidence available, there are only allegations that do not rise to the level of gross violation necessitating the deployment of impeachment and removal of the governor from the office of the county governor of Kiambu. Of course, clear malafides have been demonstrated. The impeachment is not brought in good faith. There has been violation of standing orders. There has been failure to comply with constitutional and statutory timelines and thresholds. There has been admission that part of the evidence has been procured by direct beneficiaries of the impeachment. Is that a matter which this Senate wants to rubber stamp and put a seal of approval as to how matters should then proceed in our 47 counties? Because from what shall flow from these proceedings, that is the template that shall be applied in all our counties. It should not be. Article 96, Article 81, Section 33. The Senate's role is very noble, is very clear, and if properly applied to the set of facts that are available in this matter, then there are no grounds for removal of Governor Wambura from office as the governor of Kiambu County. I will invite, within a very short period of time, Mr. Wanyama, and then from there we shall...
Order, Council.
Yes.
I realize it's now 1 p.m. and we'll have to adjourn because you'll have a balance of 2 hours, 10 minutes when we come back from lunch. So I want to adjourn the sitting, we break for lunch until 2 p.m. when we resume.